Well, welcome everyone. Good morning to everyone out there, and welcome to the junior program on insolvency. My name is Andrew Brown.
And I'm Emma Loizo.
And we are barristers at Radcliffe Chambers with special practices in insolvency. Today, we're going to be giving what is an introductory session on antecedent transactions. Just so you know, anyone who's listening, what we're pitching at today is essentially a back to basics lecture, just covering the basics of what specific antecedent transactions are, and looking specifically at issues of preferences and transactions at an undervalue. I'll cover preference payments. Emma's going to cover transactions at an undervalue. Now, with all that being said, there we go. There's the introduction to antecedent transactions in both of our names there, moving swiftly onwards if we can. So, changing that slide first to the issue of preferences. As I said, I'm going to speak about preference payments and specifically go into some of the elements of those. What we're going to talk about, at least in my talk, is we're going to talk about what are antecedent transactions first. Then we're going to talk about the actual definitions of what a preference payment might be, and then go into more detail about what is this issue of desire to prefer, followed by issues of what we call relevant time, so when these transactions might be reviewed. We're going to talk about court orders for relief, so what the court essentially might order in circumstances where it found that a preference did exist. And then we're going to talk about limitation issues, finally. And then I'll hand over to Emma for much better talking it out. So what are antecedent transaction claims? Well, antecedent transaction claims are essentially claims which allow an office holder to reverse a specific transaction and essentially to seek compensation or to reverse the movement of assets away from an insolvent estate back into the estate. Antecedent means something which has essentially come before. So you're looking at transactions that have happened in the run-up to the entry into insolvency. And there's been a lot of law over the last, say, 100 years, essentially going back to the old bankruptcy acts, which allow courts to look into transactions running up to bankruptcy. And a lot of that was codified in the Insolvency Act 1986 following the Cork report of the early 80s. In essence, the whole point is to preserve assets for the benefit of all creditors. So it's to avoid either an insolvent company or an insolvent person disposing of all of their assets right before they become bankrupt or go into liquidation, and to pull it back so all unsecured creditors will be dealt with equally. The basic, most fundamental rule of insolvency is treat all creditors equally. Unless they're secured creditors, then they get special treatment. But that's the purpose of these provisions, bring things back so everyone can get a cut. Now, specifically, the Act defines very specific types of transactions which fall within very specific relevant periods when a company or person is insolvent. These provisions apply to both corporate and personal insolvency, both of what I speak about now with preferences and what Emma's going to speak about with TUVs. I say TUVs, I mean transaction undervalues. TUVs, just a shorthand for that, apply both in personal and corporate insolvency. I speak about preference payments, which you can find at sections 239 and 340 of the Insolvency Act. Emma's going to speak about TUVs at 238 and 339 of the Act. And there's also other antecedent transactions, which we're not going to cover today because there's too much time. Section 423 claims, which are a subspecies of TUVs, they can have their own talk all to themselves. And other stuff that I would say, are much more rare, extortionate credit transactions and avoidance of floating charges. These are the kinds of claims which one doesn't see very regularly. Moving on, and before I move on, I just saw on my phone message one of the attendees, James Dyche. You wanted to know where my ship photo is at work, and I'm doing this from my son's nursery. So sorry, James, no ship photo in the background, unfortunate as that might be for you. But what is a preference? Section 239 and 340, instead of putting out both sections in full verse, what I've done is I've tried to shorten it down just for your reading pleasure. In essence, what a preference is preferring an individual creditor over the body of creditors. That's at its most simple what we're talking about, when an insolvent prefers a specific creditor in the run-up to liquidation or bankruptcy. So a more specific definition is if in the relevant time, we'll come back to that important element there, a person is one of the company's bankrupts, one of the company or the bankrupt's creditors or surety or guarantor for one of its debts. So that's the second element. The person receiving the transaction has to be a creditor or surety. And the company or bankrupt does anything which puts that person in a better position than they would have been had they not had that thing done, and the company goes into insolvency. So it's within the relevant time, the company or bankrupt putting a person in a better position than they otherwise would have been in the insolvency. That's all quite important. There's a lot to unpick there that we're going to talk about now. So some specific examples. These are all actually examples which are brought out in the Cork report. Don't read the Cork report. You can find it relatively easily if you go to any of the law libraries, and we like to trot it out in our skeleton arguments every now and then if we're banging lyrically about the purpose of some of this legislation, but it's not delightful reading. So here's some examples from the Cork report as to what a preference is and some of the things we see in practice quite regularly. Paying specific creditors' debts. That is an obvious preference if you pay a specific creditor's debt but don't pay anyone else's. Granting a charge over the company's or personal's assets. So essentially, if you own a house and you're about to go bankrupt and you give a secured charge to one of your creditors, and that unsecured creditor becomes a secured creditor to the detriment of everyone else, you're obviously preferring them over everyone else. Returning goods not paid for. Again, that might be, again, a preference. Compliance with court orders in matrimonial proceedings. So a lot of individuals, before they become bankrupt, they might have divorce proceedings, ancillary orders made off the back of that, creates a creditor in the former spouse who's now owed money, either maybe from the sale of a house or just the disposition of assets in the ancillary order. That can be a preference as well. Just because there's a court order saying that someone has to pay something doesn't actually absolve them or put them in a better position than they would have if they were a pure unsecured creditor in a commercial sense. They're all equal. The one thing this doesn't apply to, however, is assets which are held on trust, either by the insolvent company or the bankrupt. If they hold assets on trust for someone else and they dispose of them, they're not actually disposing of any beneficial interest that they own themselves. So that's not a preference. What you really have to look at is whether the company or the person is disposing of an asset to which they are beneficially entitled, something which can be sold or disposed of for the benefit of creditors in the liquidation or bankruptcy. So trust assets fall outside that. But what do we talk about when we talk about the desire to prefer? So going back just to the headline title of preferences, what is this exactly? Well, as I said, the court can order relief where it finds a desire to put the creditor in a preferential position to the general body of creditors. The state of mind of the creditor is ultimately irrelevant, but what you are looking at is the state of mind of the person making the disposal, either the company or the bankrupt, if they positively desired to do something to put that person in a better position than they otherwise would have been. Under the old rules in the Bankruptcy Act of 1914, say, there used to be language which said that the disposal had to be with the dominant purpose of putting that creditor in a better position. Well, that's no longer the law. Mr. Justice Millett, as he then was, in this case of re MC Bacon, which I always remember because Bacon is in the title. In re MC Bacon, Mr. Justice Millett noted that the language of the statute no longer requires that. There just has to be a desire to prefer a creditor. It doesn't have to be the dominant intention or the dominant purpose. It merely has to be a desire of some way, shape, or form. And when it comes to bankruptcy, this is quite easy to look at. You look at the bankrupt, it's one person. That's all you're concerned about, is what was their state of mind, what was their desire when they made the disposal of an asset. Well, that's not true when it comes to a company. A company is a little more difficult. You're actually looking at the directors of the company, because the directors are essentially the controlling minds of the company. The company is a living person, but the directors are the brains of that company, or brains of that living or legal person. So you have to look at them, which makes things a little more difficult. But actually proving the desire to prefer, this is really more when we get into the reality of these claims. It can be quite difficult. Anyone who's dealt with any sort of claim, any sort of fraud claim, anything involving subjective intentions, it can be difficult to know exactly what an individual means, what an individual wants or desires when they do something, especially if there's no smoking gun. Sometimes you get idiots out there who, right before they go bankrupt, write an email saying that, oh, I'm going to give you my house because you're my favorite creditor, and I want to make sure you're paid off in the future so that we can have a good relationship going forward. Those are really easy cases. But most cases don't have that kind of evidence. You have to dig. You have to try to look at inferences created from the material around it. So you look at all the contemporaneous material around. You look at emails, you look at letters, you look at company minutes if you're talking about companies, and you're looking again for anything in that documentary material which might indicate a desire to pay one creditor rather than others. So someone saying, hey, I think things are about to go bust, but don't worry, you're going to get yours. Those kind of statements are the things you're looking for. And then you look at the facts that surround it. So if there's a big body of creditors, no one gets paid anything except for one creditor who does get paid everything, then from a commercial context, you start to look at it and you say, well, hold on a second. It's obvious here. One person is being paid and no one else is being paid. Why was that happening? If you can't find a good justification for that, we'll talk about justifications a little later, then that's pretty good inference material to indicate that there was some sort of preferential desire on the part of the payer. However, helpfully, because these things are quite difficult to prove, Parliament, in all of its great wisdom, actually gave us a nice statutory presumption which operates on our behalf. So where the person receiving the funds, where the creditor is actually connected or an associate of the bankrupt or insolvent company, then the court will presume a desire to prefer, which is great. So you actually get to reverse the burden of proof. So we'll talk about in a second what a connected or an associate person is. But say if I were to go bankrupt tomorrow, and if I gave all my assets to my wife today before doing so, then what the Act says is that essentially the starting position would be that under law, I would be taken to have desired to make that payment for my wife as a preference. So then the burden shifts to me to disprove that, which can be very difficult to actually disprove that. So it's a lovely weapon to use in these kinds of claims. However, with that being said, best practice, the courts have said best practice is not to rely solely on presumptions. And you would never want to in any event. You always want to back up your presumptions with at least an attempt to prove the preferential desire on the evidence as well, because if someone does overcome the presumption, you want to actually be able to stack up evidence against them as well. Courts don't like you being lazy in relying on presumptions. That's my experience, at least. In the ICC, you'll usually get dragged a little bit if you just rely on the presumptions. Judges don't want you to do that. They want you to go into the facts themselves. So always go into facts. What about a potential defense to this issue of a preference? So if a company is forced, or a bankrupt, a sole trader, let's say, for good commercial reason to prefer a creditor, a specific creditor, then it will not be taken to have desired the actual effect of a preference. In essence, choosing the lesser of two evils is not the same as desiring to put a creditor in a better position. And what that comes from, again, is to go back to my favorite Bacon case, re R.C. Bacon, or M.C. Bacon. A secure existing, in that case, the company had to secure an existing debt to an unsecured creditor in order to avoid immediate liquidation. So they had a lender who they owed a significant amount of money to. The facility was coming due. That lender said, we're going to put you into liquidation unless you give us a secured debt. Now, in those circumstances, it's essentially a hostage payment. And Emma's going to talk about these with TUVs a little more, as they're enshrined in TUV law. But where you have these kind of hostage situations where a company or a sole trader has to do something in order to try to survive in the near term, it's not about desiring to put someone in a better position in an insolvency so much as it's desiring to survive financially. And that is a different position. So that is actually a good defense to these kinds of claims, although somewhat difficult to make out in times. Now, to go back, we talked about preferences have to fall within what we call a relevant time. What is a relevant time? So it's defined, and we said in 239 subsection 2, that's where relevant time is required. But the starting position is, if the person who received the funds is not connected to the company or is not associated with the bankrupt, then the starting position is 6 months prior to the onset of insolvency. So that is your period, 6 months ending with the onset of insolvency. Now, obviously, in the case of winding up petitions or bankruptcies, that's the presentation of the petition, not the actual making of the order, but the presentation of the petition. Because in insolvency law, you backdate the onset of insolvency. If a winding up order is made or a bankruptcy order is made, it's backdated to the actual presentation of the petition date. So that might go back a long time. So you actually look at 6 months leading up to that petition. If a transaction falls within those 6 months, you want to look at it. You want to look at who it was made to. You want to look at why it was made, because you might have a preference payment and you might be able to reverse it and get it back into the insolvent estate, which has the double benefit of both paying the remuneration of the trustees and your own legal fees, which can sometimes be a very important consideration for lawyers. But for connected persons or for associates, that relevant time actually expands. So instead of it being 6 months prior to liquidation, it actually moves back to 2 years, which is obviously a huge jump in time. You get a lot more time to actually deal with things. So a lot more transactions to look at. Now, the further you get back, the further you get away from liquidation or bankruptcy, more difficult it is really to try to connect a dominant, or not a dominant, but some sort of preference intention. But still, you can look at it. The closer you get to that 2-year limit, the more judges might start to question whether the intention is there or not, the desire to prefer is there or not. So you have to work harder at proving it the further away from liquidation or bankruptcy you get. Now, I mentioned the presentation of a winding up petition or a bankruptcy petition. Those are the obvious cases of an onset of insolvency, but it can also be the filing of an application for administration or a qualified footing charge holder, giving notice of appointment of an administrator. Those are the onset of an insolvency event as well. So if something goes into an administration, these kind of claims still exist. It's not just pure liquidation or bankruptcy in which these claims exist. You can look at administrations as well. What are connected persons? Who are connected persons, I should say? Connected persons are defined by sections 249 and 435 of the Insolvency Act. For bankruptcy, it's very easy. It's spouses, it's relatives, it's business partners, pure business partners, not just people you do business with, but actual people you're engaged with in a partnership. And relatives can include adopted children, it can include stepchildren, it can include half brothers and sisters. Again, reference to Harry Potter there with the half-blood prince, lovely. Those are the people you look at to see whether they're connected or associates. When it comes to companies, it's a little more tangled. You can look at directors. Directors are obviously connected to the companies. So if a company owes money to a specific director under a director's loan, and suddenly it pays back that director's loan and then goes into insolvency the next day, obviously a preference payment. Well, most likely a preference payment, but you can see why they would be considered connected, because they're the ones controlling the actual payment itself. The same exists for the associates of directors, so directors' spouses, directors' children, directors' brothers and sisters, directors' business partners under peer partnerships. Again, the point is to prevent directors of companies essentially manipulating the company's assets to help someone that they are connected to, since they are the controlling minds. It can also include other related companies. So sometimes companies are subsidiaries of the same parent company. They would then be connected companies. So if one company is merely shifting its assets to its brother or sister company or to its parent company, then that could be a connected company, which can give you a longer time and give you a presumption in your favor. So look at the relationship. Always look at the relationship with the person to whom payment is being made, either company or the individual. Try to find the connections if you have to. Sometimes you have to dig to find the connections, but look to see if they're there. So again, issues of relevant time here. the company or the person has to be insolvent at the time of the payment. So this is a further definition of relevant time. So not only must the payment be in that window of 6 months or 2 years running up to the onset of insolvency, it also has to be at a time that that person is insolvent. Now, when I say insolvent, I don't mean, obviously I'm using insolvency in two contexts here. There's formal insolvency, which is the entry into winding up or bankruptcy or administration, something to that effect. That is formal insolvency. But an individual or a company can be insolvent without being formally insolvent. Someone can be broke, but still be walking around and not have been made bankrupt yet. And that's what I talk about when I say, that's what I mean when I talk about being insolvent at the time of the payment. So the company, what you would normally do is the courts will apply the old test under a case, Supreme Court case from about 10 years ago now called Eurosale, where you look at the commercial reality of a situation. You look at the balance sheet of the person making the payment and the cash flow perspective of that person to see whether they are insolvent in all of the facts at the time the payment is made. Now, sometimes that's very easy to prove. A lot of people might have debts of, let's say I'm walking around and I've got debts of £1 million and I only have £1,000 in assets, and I shift those £1,000. Well, obviously I'm insolvent by the tune of £999,000. So I am balance sheet insolvent on that day. My creditors might not have demanded payment for all the other £900,000. So I might not be cash flow insolvent on the day, but I'm certainly balance sheet insolvent. And if I've disposed of those assets on that day, I am insolvent when I have disposed of those assets. That's what you look at. It's an accounting sort of accounting procedure you have to do. And sometimes that's very easy to prove. Sometimes it's a lot more difficult to prove. If you're looking at these kind of claims, look at all of the assets of the insolvent at the time of the payment. Did they own a house? Did the company have statutory records? What was in those statutory records? Can you find their management accounts for that current accounting period? What does that contain in it? What were the current debts? What were the current assets? Set them off against each other. If the payment actually makes the company or the person insolvent, that also can be a preference. They don't have to necessarily be insolvent the second before they made the payment. If the payment tips them over into insolvency, then that's the same as if they were insolvent. So a bit of accounting exercise you need to go into. It's the kind of thing you need to flesh out in your actual claim as well when you actually plead it. And again, Emma's going to talk about procedure in a few minutes, but when you do the claim, when you set it up in the documents, when you plead it, you need to make sure you cover all of that. Now, before I go on to relief, I completely forgot when I did these slides, there's a slide missing here, which is putting the creditor in a better position than it otherwise would have. I'll go backwards here to avoid discussions of relief. Missing slide, dealing with that. So the payment has to put the creditor in a better position than it would have been had it gone into the insolvent state. And what that means is, again, a second accounting exercise you have to complete. So you need to prove, if you're acting for an office holder in these cases, I should say, that if the creditor was just having to prove in the insolvency as an unsecured creditor, that they would not have received the same amount of money. So in a really badly insolvent estate, bankruptcy estate, let's say, unsecured creditors, let's say, are going to get 1p on the pound, that's 1% of their debt, and one individual creditor gets 100p on the pound. So they get paid their entire debt before the bankruptcy. It's obvious they are in a better position than they otherwise would have been because they received all of their debt, and otherwise they would have only received 1% of it. Now, that is an accounting exercise. That's an extreme example, but one which you need to conduct when setting up the case as well. So it's pretty easy to do usually. You look at what is the return going to be to the general body of creditors. That's usually in the statutory reports of the trustee or the liquidator. You see what they would have gotten. You figure out what that percentage of debt would be. You obviously multiply whatever the debt would have been by that percentage and find out what the return is. And then you look at what the actual payment was and compare the two. But that is a comparison that needs to happen. That accounting exercise needs to be set out as well in any claim that you bring. On to relief. We're narrowing down here on the end of this talk before we move on to TUVs and Emma. But both in the corporate and the bankruptcy fields, the court essentially has the same statutory language for the orders it can make. It says the court shall make such an order as it thinks fit for restoring the position to what have been if the company had not given that preference. Obviously, replace company with bankrupt if you're talking about bankruptcies. That is a broad discretion. Now, you might read that and you think the court shall. The word shall you might think is mandatory and the court has to make an order. Well, you would be wrong if you think that, as I learned quite recently in a case I did. The Court of Appeal case from 1993, re Paramount Airways, actually says the word shall doesn't mean a court has to make an order. The court can award absolutely nothing if it wants to. So you might make out your preference claim against a debt or against a creditor, and the court might say you've achieved everything you need to, but you know what? Under the circumstances, we're not going to make an order because it's not just to do so. And I had a case this summer specifically on that. The first instance case was in the Insolvency and Companies Court last year in 2020. The appeal was this year in 2021 in front of Mr. Justice Trower. In that case, we proved every element of the preference, but ultimately the court declined to make any award. Ultimately, the court said that injustice would be done to the creditor, which would outweigh the actual benefit to the insolvent estate, the bankrupt. And so the court, quite exceptionally, didn't make an order in that case. And this is an exceptional circumstance where a court will not make an order. Courts can make orders to simply say, tell the creditor to make a payment back to the company or to return a specific asset, say the shifting of a house. If the bankrupt shifts the house to his wife or to her husband, then the court can order simply the return of the beneficial interest of that house to the bankruptcy estate. You might do that if you're trying to look at an appreciation of the value of the property beyond what it was at the time to try to sell it. Conversely, you might just ask for monetary relief. Brings us on to the very end of the talk, limitation. When we talk about different orders the court can make, we have to talk about limitations. So Limitation Act obviously defines the periods of limitation for different claims. Sections 8 and Sections 9 of the Limitation Act 1980 is what we're actually speaking about. Another case I dealt with, a High Court case, re MSD Cash and Carry, is sort of the guiding principle as to how limitation applies in these kinds of cases. It all comes down to what His Honor Judge Hodge said in MSD. It all comes down to what you're seeking in relief if you're acting for the office holder. If what is sought is purely money, then this falls squarely into the ambit of Section 9, so you get a 6-year limitation period. And that'll be 6 years running from the appointment of the office holder. So that would be usually the winding up order or the bankruptcy order, not backdated to the petition, but the actual making of the order usually. 6 years if you're seeking monetary relief. But if you're seeking something else, something which is non-monetary, it's actually 12 years, falls under Section 8. And the reason this came up in the case of MSD Cash and Carry is it was all about the offset of DLAs. So in MSD, the directors owed various monies to the company under director's loan account. And what the company did was gave a credit note against those DLAs because it said that, oh, right before we go into liquidation, we're going to actually wipe away these directors' loan accounts by giving a credit against them. And what the court said, because we had a tussle over issues of limitation, I acted along with Jeremy Cousins, Queen's Counsel, for the defendants in that case. And we said, well, it's money at the end of the day. This is a 6-year limitation period and they're out of time. What the court ultimately decided was no, it's not monetary relief you're seeking. You're simply seeking the reversal of an accounting transaction. That is not money you're actually trying to get back. You're just trying to reverse an accounting transaction. The issue of enforcing that is something else. But in that case, it was a 12-year limitation period, the court determined. So that might apply if you're looking at the return of assets, say cherished number plates or property, something to that effect. That would be a 12-year period. However, in most cases, what you're seeking is money. So usually you're looking at 6-year limitation periods. Now, if you're acting for someone other than the office holder, if you're acting for a defendant, look to reverse all the things I talked about. Your defenses are going to be attacking these various required elements. Look at limitation. Look at the desire to prefer. Can you disprove the desire? If you're acting for a connected person, can you overcome the presumption? Sometimes that is incredibly difficult, and sometimes that is a good reason to try to settle early. Look at the accounting exercises. Was the person insolvent at the time the payment was made to your client? Conversely, is your client in a better position than they would have been? All of these things you need to look at when you look at statutory defenses to these claims. And it's important to go into this. There's a lot of scope in preference claims, a lot of scope in TUV claims as well. We're trying to argue this, but at the end of the day, it's important to remember that office holders are unemotional about these claims. So they're not doing this out of spite. They're not doing these kind of claims because there's some familial issue between the parties or some neighbor dispute over a party wall. Emotion is not there. It's about money at the end of the day. So settlement is something which counsel can always advise on, but it is always an important consideration in insolvency claims. It's money at the end of the day. And that's what really should try to drive some sort of ADR prior to getting to actual trial. Now, so we're going to go on to Emma and the issue of transactions at undervalue. So Emma, do you want to take it away?
Yes, thank you very much, Andrew, for that great talk. Okay, so as Andrew mentioned at the start, I'm going to be talking today about transactions at an undervalue. So I'm going to start by looking at what these claims actually are. Then I'm going to turn to the requirements of bringing a claim, and before looking at the relief that the court may order, finally go on to consider some defences, and then finish by considering briefly the procedure. So Andrew's already outlined at the beginning of his talk what these antecedent transaction claims involve. TUV claims are statutory claims. They're found in the Insolvency Act 1986, and they apply to both corporate insolvency and personal insolvency. So the main provisions are found in section 238 and section 339. If it's in corporate insolvency, then it's brought by an administrator or a liquidator, and in personal bankruptcy, it's brought by the trustee in bankruptcy. These claims are essentially designed to stop companies and individuals transferring assets away to benefit their associates and connected persons, which then deplete the insolvent estate and disadvantage creditors. Transaction at an undervalue claims overlap to some extent with section 423 fraudulent transactions, but I'm not going to be dealing with those today, as Andrew has mentioned at the beginning. There's just too much to cover in one talk. So looking at the requirements, which are set out in 238 subsection 2 and 339 subsection 1, in both corporate and personal insolvency, there are really three elements that need to be proved to bring a claim. The first is that there's been a transaction that's been entered into by the company or by the individual. The second is that that transaction is at an undervalue. And the third is that the transaction that's been entered into is at the relevant time. So the provisions essentially mirror one another. There's no requirement to prove an intention to injure the company's assets or an intention to deplete assets. And unlike in section 43, which I've said I'm not going to talk about, but I'll just briefly mention distinction, where you have to show under section 423 that the debtor had the purpose of putting the assets beyond reach of a person that was making a claim, or otherwise prejudicing the interests of such a claim. So starting first with what a transaction is. Well, this is defined in section 436 of the Insolvency Act, and it includes a gift, agreement or arrangement, and references to entering into a transaction shall be construed accordingly. Transaction is defined broadly, embraces a wide range of possibilities, so it can include both contractual and non-contractual agreements. What's important for this part is that the company or the individual has actually entered into the transaction. So there must be some sort of act of participation. So unilateral misappropriations by a director of company assets wouldn't be a transaction between the company and the director. And similarly, transaction by a mortgagee would not be entered into by an individual. So that's transaction. The second element is the undervalue. And there are two options for a company and three for an individual. The first is that the company or the individual makes a gift to another person or enters into a transaction on terms that provide for the company or individual to receive no consideration. So that's common to both individuals and companies. The second option, common to both, is that the company or individual enters the transaction for a consideration the value of which in money or money's worth is significantly less than the value in money or money's worth of the consideration provided by the company. And I'll come on to talk a little bit more about that in a moment, because that's likely to be the most contentious option. The third option that's available for only individuals is if a person enters a transaction with a person in consideration of marriage or the formation of a civil partnership. So looking at this where the consideration is significantly less, as I've mentioned, this is likely to be the one that causes the most contention. It's looked at from the view of the debtor, and essentially what the applicant needs to show is that the respective values in money or money's worth, what was received was significantly less than what was provided. So, for example, if the company or individual is selling assets or providing services for less than market value. So really here, one of the things that the applicant's going to need to be doing is considering what price the property representing the consideration is going to obtain in the open market and what a purchaser would pay for that in the open market. The third element is this relevant time. So the transaction and undervalue must be entered into at the relevant time. Andrew's already spoken a bit about relevant time in terms of preferences, and common to both, I suppose, is that they're defined by reference to the insolvency or bankruptcy. So looking at a company, this is dealt with in section 240 of the Insolvency Act. The transaction has to be entered into at a time in the period of 2 years ending with the onset of insolvency. There's other rules for administration, so the relevant time is at a time between the making of the administration application and the making of the administration order, or the time between the filing of the copy of notice of intention to appoint the administrator and then the making of the appointment. The onset of insolvency is determined by reference to section 240 subsection 3, and Andrew's already explained the different examples. So for example, in liquidation, it's the commencement of winding up. In administration, it can be where the administrator is appointed by an order, then the date in which the application is made. And these, as I said, are all set out in that subsection. Coupled with this relevant time and the 2 years is the fact that the company at the time that it enters into the transaction as an undervalue must be insolvent or become insolvent as a result of the transaction at an undervalue. There's a presumption here if the transaction is with a connected person, and this is going back to the slides that Andrew has already kind of referred to. The connected persons can be directors and the associates of directors. And what if you can't rely on the presumption, obviously it's not best practice to rely on the presumption, but you're going to need to be looking at the annual accounts, for example, to see what the company's situation was in the years leading up to the insolvency. Now, for individuals, the time frame is much more generous. So it's 5 years ending with the bankruptcy petition or application. And the insolvency requirement is actually only relevant where the transaction is made more than 2 years before the bankruptcy application or petition. So if you're solvent more than 2 years before, then provided you don't become insolvent as a result of that transaction, then the transaction won't be impeached. But if the transaction is entered into less than 2 years, ending with the bankruptcy petition or application, then it doesn't matter whether you're solvent or insolvent. And section 341 defines insolvency as the unable to pay debts as they fall due, and where the assets are less than the liabilities, taking account of contingent and prospective liabilities. Just like with corporate insolvency, there's presumption here. So when the transaction is entered into with an associate, and this is widely defined in section 435, spouse, civil partners, relatives, as already been discussed. Like with preferences, the relief is dealt with in section 238 and 339. The court, it's not in the same statute, but it's the same provision essentially. So shall, on such an application, make such order as it thinks fit for restoring the position to what it would have been if the company or individual had not entered into that transaction. Wide discretion and examples of the relief are given at section 241 and 342. For example, the court may require that any property that's transferred as part of the transaction is then vested in the company or individual. And it may also provide for tracing, so allowing for property that's been transferred to then be traced into the proceeds of sale. And as Andrew has already discussed, even though it's sort of couched in mandatory language, the court can still decide to award nothing where justice requires it. So if you're looking at it from the other side and the defences, then what you're going to be looking at is whether the statutory requirements are met. So did the individual and company actually enter into the transaction? Can you get rid of it that way? Or can you say that the transaction was not at an undervalue? So there was consideration given and consideration wasn't significantly less than that provided by the company or the individual. Or can you get around it by saying, well, the transaction wasn't entered into at the relevant time. So for an individual, it was more than 5 years, or for a company, more than 2 years. Or finally, that the insolvency requirement was not met where it has to be met. For a company, there's also a statutory defence for good faith transactions. And this is just for companies. There's no equivalent for individuals. So under section 238, subsection 5, the court won't grant an order if it's satisfied that the company which entered into the transaction did so in good faith and for the purpose of carrying on its business. And at the time it did so, there were reasonable grounds for believing that the transaction would benefit the company. So as Andrew alluded to at the beginning, this is designed to exclude commercial transactions such as ransom payments that are made to ensure the company can keep trading, to retain contracts where, because of its insolvency, it may have to accept terms that are to its disadvantage. So the first requirement, the good faith requirement, is a subjective test. So here we're looking at the state of the mind of the directors, so whether they really entered into the transaction in good faith. The second element, B, is objective, and what we're looking at is sort of scrutiny into whether there were grounds at the time where the company could believe that the transaction would benefit the company. That's statutory defence for companies. With both companies and individuals, there's also defences for third parties. This is to protect those who have acquired an interest in the property from a person other than the company or the individual in good faith and for value. So any order made shall not prejudice their interest in property or require someone who's received a benefit from the transaction in good faith and for value to then pay a sum to the office holder or the trustee, except where that party was that person was a party to the transaction. For good faith, there's a rebuttable presumption that applies against good faith in certain circumstances, and this is set out in subsections 2A of both sections. And this is really where the third party had notice of relevant surrounding circumstances and of the relevant proceedings. So for a company, the relevant surrounding circumstances are the fact that the company's entered into a transaction at an undervalue, and that's the same for an individual. For the relevant proceedings, it's notice of the administration application or order, notice of intention to appoint, that a winding up petition has been presented. So there's an awareness of those proceedings. And in bankruptcy, it's the fact that the bankruptcy application or petition, as a result of which the individual is made bankrupt, has been made or presented, or the individual is made bankrupt. So relevant circumstances and relevant proceedings, or for the company and the individual that the transaction the person is connected with, or an associate of the company, or connected with the individual and person. So the kind of connection element there. That's where the rebuttable presumptions apply against good faith. Finally, on to procedure. So similar to other types of Insolvency Act applications, they're made using application notice supported by witness statement, and then the defence will be evidence in response, and there may be evidence in reply. In certain cases, the court may order points of claim and defence to be filed. These are similar to statements of case and Part 7 claims. And it may be a case where you may need to consider getting expert evidence, for example, for valuation to determine the value of the consideration that's given, especially in situations where you're trying to show that the value given is significantly less given by the company or the individual. If it's opposed, then the first hearing may be used as a directions hearing, similar to other types of insolvency matters. So that is transactions at an undervalue. Be rejoined by Andrew, and we can look at some of the questions.
Well, why don't I, there were a few questions on preferences, Emma. Why don't I answer those, and I'll give you a chance to actually read any questions on TUVs and actually think about the answer.
Thank you.
Rather than put you on the spot. So Annabelle Hollis had a question about trusts and preferences, and she asked where a company or a person transfers assets into a trust prior to be made insolvent for the benefit of someone to avoid them being touched in the insolvency. Could that be a preference? So I talked earlier about the actual transfer of assets which are held by a company or a bankrupt as trustee, and how that wouldn't attract preferential liability. The transfer of assets into a trust for the benefit of someone else might be a preference payment, yes. So if that happens in the relevant time and it's done with the dominant, or not the dominant again, if it's done with a desire to put that person in a better position than they otherwise would have been, which it likely would be if you're settling something on trust for someone shortly before you're made insolvent. That also might be a TUV, because putting something into a TUV or putting something into a trust right before an insolvency might essentially be grounds to say that something is an undervalue if you're not getting anything back. So in short, that's the answer, Annabelle. Putting it into a trust might be a preference, has to be in the relevant time, still has to meet the desire test, and still has to go through the accounting issues. Monica asked, under what circumstances could the court consider a relief order not fair and equitable? So I think what you mean there, Monica, is when would the court consider not making an order because it is unjust in doing so? So I wrote out some of the facts from the case that I dealt with, the Summer of Folds. In that instance, the court decided it would be draconian to order relief against the creditor defendant. In that case, the defendant was the stepdaughter of bankrupt, if my memory serves. She was, while the stepdaughter, so therefore a connected person, the payment to her fell just within the 2-year period, but she was in essence a commercial creditor in that she had done commercial work for the bankrupt in her role as an accountant. And that was what the payment was for. The payment had the result that she got paid, not completely in full, but got a significant chunk of her money. But the only other creditor in the bankruptcy received nothing. So it was essentially a sole creditor bankruptcy. So it was almost weighing up the interests of her versus the other creditor in the bankruptcy. She had disposed of the money she had received largely in good faith without knowledge of the claim. And the result would be that if an order was made against her, she was a single mother living in a house which would have to be sold, essentially making her and her child destitute and have to seek housing accommodation through the council. And she would receive very little money out of the sale of that house because most of the proceeds of sale would go to the bankruptcy estate to pay for the cost of the litigation and the sums sought in the preference. So in those circumstances, the court considered that it would have been draconian to make an order unjust to do so, where it was essentially a good faith receipt by the creditor. She had disposed of the assets almost in a change of position, but you can't really do change of position in these claims. And there would be very little benefit to the bankruptcy estate compared to the detriment she would suffer and her child would suffer. So that's what I talk about. And that was an extremely exceptional case based on the facts of that case and based on the evidence of that case as well. These kind of orders of not giving relief do not come up often. The examples are extremely few and far between in the last 30 years, almost 40 years, 35 years now, isn't it, since the Insolvency Act in 1986 came into being. And you can count on one hand the number of cases out there where no order for relief is actually made. So you need to cover all your bases when you bring the claim, and maybe you need to hammer the defendant a little more from a prejudicial standpoint to try to cover off good faith. But in reality, you're not going to see those kind of orders very regularly from the court. Now, with that being said, Emma, do you have some questions you want to answer?
The other question is about unlawful dividend payments by a transaction at an undervalue. Whether an unlawful dividend payment could be a transaction at an undervalue.
Well, the Supreme Court should be handing out judgment on BTI and Sequana relatively soon. But yes, I can't see why not. If I remember right, BTI and Sequana also dealt with 423s, didn't it? The actual facts of the case are fleeing my mind. But sure, why not? But the answer really is wait for the Supreme Court in the next month or two and see what they have to say on any given thing.
There we
go. One procedural element, I think, for both of these claims to cover is something which came up in the case of Manolay back in June of this year. What that concerns is 423 claims, which we didn't talk about today. They're species of TUV claims that Emma was talking about, and they can go back. There's no relevant time for 423 claims, so they can go a long ways back into the distance. Traditionally, when we have brought antecedent transaction claims, we have often coupled them with 423 claims, either TUV claims, preference claims, misfeasance claims, all the kind of bread and butter claims we do in insolvency. You pair often with 423. You can't really do that anymore because 423 claims under recent case law from the High Court are now considered to be Part 7 claims. So they fall outside the same procedure. You have to do Part 7 proceedings. You have to do particulars of claim, normal sort of procedure for any sort of Part 7 claim, rather than the accelerated procedure for insolvency. It also can be quite painful because in insolvency, we only have to pay, I think it's £100 to issue an application. Do you remember, Emma? Is that right?
Roughly, I think around that. Yeah.
Yeah, which is great. So if you act for an office holder, it only costs £100 to issue a claim. Whereas if you do a Part 7 claim, it can cost up to £10,000 to issue a claim. So when you do these kind of preference and TUV claims, it's very cheap, other than obviously paying very well for your barristers to put them together. But they're very cheap to issue, whereas 423 claims are very expensive to issue these days. Now watch this space. There's a lot of lobbying going on to try to change the insolvency rules so we can try to bring those 423 claims back into the ambit of the claims we just talked about. That's just something to be aware of. Maybe that's way too specialized for what the purpose of this talk was. But I'm trying desperately to fill the 5 minutes so you get a full hour of CPD. And that is very important to me. That no one is left wanting for more. So that's something that's very important.
Thanks for joining, everyone. Have a good rest of the Tuesday.
Yeah, thank you, everyone. Have a lovely day. And give us a call if you have any questions. Don't forget. Reasonable rates. Lovely people.